Hi, welcome back to our Queer Column podcast. Today we have Karan Gulati with us, who is a research fellow at Vidhi. He's in the corporate and financial services wing. But today we're here to discuss his 2021 paper in the Indian Law Review on inheritance rights in India for transgender persons, which he wrote along with Tushar Anand. So, Karan, why don't you start with introducing yourself and your work?
Thanks. I mean, I think that's a fairly exhaustive sort of introduction because work travels from office to office. So right now I'm at the Vidhi Centre for Legal Policy, where I work with a corporate law and financial regulation vertical. The name is sort of self-explanatory. But before this, I was at the National Institute of Public Finance and Policy, where I worked across a sector of teams from grievance management, judicial administration, to land and property rights. And that's where this paper originated with a few colleagues of mine, including Tushar.
Okay, thanks. Nidhi.
Yeah, could you provide us a brief of your paper for our viewers?
Yeah. So we started really with the question. I mean, as any research does, we started with the question just to know what is happening. And we would have preferred if we found a positive result and found that, inheritance rights of transgender persons are excellent in the country. Unfortunately, as we expected, that was not the case. So how we went about it in our inquiry was to have a doctrinal examination. What that means is that we only looked at the text of the law as well as judgments to understand how inheritance rights have both developed, because through the research we found that transgender individuals did have some rights in pre-colonial India, and we wanted to trace their development. And we also wanted to know what is the position today. What this research, however, specifically lacks is lived experiences and practical realities. And we've only focused on how is the law and judicial interpretation leading to any discrimination. We understand that this is not an exhaustive exercise. And even if the law were to be excellent, and we've given some recommendations on making it at least a little better, even if that were done, this does not mean that there would not be problems faced by individuals.
Yeah, thank you for that. But Karan, in your paper, you talk a lot about what are the implications of the law using the terms only man and woman in the text,
Mhm.
which is a very fair analysis to do and it's easy to understand for someone who's familiar with the intricacies of family law. But why don't you, for our viewers, explain what the implications of this are? And you've given a very wonderful example in your paper where, say, if a person dies and their mother is alive, what would be the implications if they're categorized as male or female? So why don't you run us through that once?
Right. So some of this work sort of leans on previous work done by the National Institute of Public Finance and Policy on uh, inheritance rights of women. In particularly, that paper looked at the Hindu Succession Act. And what that paper found was that there were differential rights for inheritance between men and women. Now, when we translate within the purview of the Hindu Succession Act, now when we translate that to transgender individuals, what we see is that the law, both the Hindu Succession Act as well as the Indian Succession Act, usually use male and female pronouns at different instances. Now, this would be absolutely just using male pronouns would not be nice, for the lack of the better word, but it would be okay because the General Clauses Act, which is a definition act in India, says that unless the context requires, a reference to a male pronoun also means a reference to a female pronoun. So when drafting a legislation, would not have used that, but that would be okay, right, legally speaking. But what has happened is not only is there differential usage of pronouns, there are differential rights between men and women. So if a transgender individual is recognized either as a male or a female, and of course this does not account for them accounting as a identifying as a non-binary, but let's say they're counted as a male or identified as a male or a female, they would have different rights under the legislation. So this is a problem rarely happening across the spectrum. Women themselves are suffering from this because why should they have differential rights? And because they have differential rights, anyone who either identifies as a male or a female has different rights depending on their identification. So as you said, we've gone into some examples in our paper, in particularly in the Hindu Succession Act, for example, a woman's property devolves to her children, if I remember correctly. Self-possessed property, it devolves to her children upon her death if she's died intestate. Of course, again, this does not account for wills, right? So this is only a case where someone has passed away without a will. However, if the woman does not have children, it dissolves onto her husband's family, right? Whereas if a male person passes away and does not have children and does not have a will, it dissolves onto his family, right? So at the end of the day, if there's a couple, binary couple, and they without any children and they pass away intestate, the property is passing over to the husband's family, both of their self-acquired property, right? Now, in this situation, it's easy to understand that if an individual recognized recognize themselves either as a male or female individual, their property either goes to their own family or their partner's family. What this does is it leaves it open to the interpretation of a local bureaucrat to see which path this property should take. That's not only detrimental to the right of this individual, it's detrimental to the law of property itself. Because how property is devolving is now in the hand of an arbitrary individual deciding how this property shall devolve onwards. Similar examples can be found in the Indian Succession Act, which is a tad bit better because it tries to have more gender neutral provisions, but it does have its own failings as well. And we've given examples to that instance in our paper.
Yeah, I think that explains because in most of the articles that we have read about property, even in our courses, there's this implication of gendered nature of property which always exists. So, for example, Beena Agarwal's work about gender and land rights, and about also Kritika Ashok's work that recently came out, where they analyze how property does pass from male heirs to female heirs. So, I think that does explain what you're talking about. So I just wanted to also understand what was your inspiration for understanding such a niche area of law specifically, given that most of the academic articles have mainly been about, let's say, how it impacts women or women minorities specifically.
So it's rarely, I mean, as research is, it's often non-linear. The inquiry started by my colleagues at NIPFP into, as you said, the common research area of property devolving onto women and men differentially. And it is only after that inquiry which resulted in unfortunate but obvious results that there is different legislation. We realized that this can have an impact on transgender persons as well. And so that research carried forward. This is not to say that this was the targeted paper, which it often never is. We started with just, as I said earlier, to figure out what the position is. And we might have found something very different. It's just that it was shaped over the course, the paper took shape over the course of the research. For example, and as we may discuss going forward, we found that judicial interpretation on the subject matter has been relatively positive. I would still not want it to the discretion of the judiciary to be deciding these laws, but at least till now it's been relatively positive. That is not something we expected going into the paper or even thought we would be looking into going into the paper. And sorry, since you named some individuals, Beena Agarwal's work was too notable in the sense of course, it was important and sort of formed our basis, but we also stood on the shoulders of some other giants like Shipra Deo and others who focused on rural property. And I think that's a separately important part to consider, which our paper does not go into, because again, as I said, it's a doctrinal research, but there may be differences in succession between urban property and rural property, because those differences have been shown in the cases of women. And if someone wants to join, I would love to be part of the research, but I think other people can explore that themselves as well.
Yes, thank you for that answer, Karan. Now I want to discuss the reforming the law section of your paper. You talk about the the Transgender Protection of Right 2018 Act that Pakistan had passed. And a similar legislation in India is the Transgender Protection of Right 2019 Act. But
Yes.
you talk about how the Pakistan Act specifically protects inheritance rights of transgenders. So do you think that we missed something that Pakistan didn't? And do you think we can learn something from the Pakistan Act? Why don't you talk about that?
Okay, so this actually sort of excellently plays into the relation between of the position in law versus lived realities. And the Pakistan legislation was enacted, if memory serves, in 2018. Our legislation came in 2019. The Pakistan legislation says that if an individual identifies as a male, they shall inherit as a male. If they identify as a female, they shall inherit as a female. And if they identify as a non-binary, it's weird maths that's then expected is that half of the property shall devolve as if they were a male person and half of it should dissolve as per if they were a female individual. I'm not sure how that's implementable, but at least it feels like some care was taken in having this provision. It may or may not have been better drafted, and that's for Parliament of both Pakistan and other countries to see how legal drafting can be done. But at least there was some thought behind having such a provision. Unfortunately, the Indian legislation that came in 2019 does to some extent protect property rights. It talks about rental property and that an individual shall not be separated from their rental property based on whether they're a transgender individual or not. So it did think about that aspect, but it did not about inheritance rights. Now, to some extent, that's understandable because that's governed by a separate legislation, which of course we found is not appropriately designed, but that's governed by an Indian Succession Act and a Hindu Succession Act. And perhaps Parliament did not want to mix these two dynamics, right? But we do feel that it would be beneficial to have a provision to provide that no discrimination shall happen on the grounds that an individual is a transgender. This language is there in the 2019 legislation. No discrimination shall happen in matters of succession and inheritance, right? And that itself is complicated and requires other amendments. So it requires gender-neutral provisions in succession legislation themselves. Now, why I, at the start of this, said that this sort of plays into what lived realities versus doctrinal realities is though the Pakistan legislation does point towards some care and thought, since that legislation, and more so since our paper was finalized, there have been protests against that legislation, right? And it seems like a part of society does not want that legislation to come to play or does not approve of that legislation. Now, of course, there's a whole debate on which should come first. Do you have a progressive legislation first or do you convince society first? And that's sort of beyond the remit of whatever I can offer. But it does sort of play into the fact that it's not as easy to solve this by legislation. So even though we have some recommendations, and we do believe that they will play a part in taking this forward, there needs to be more discussions and more accountability in general before I don't know before any of this happens, but at least during any of the amendments happen.
Yeah, thank you for that. Sticking to the Indian context again, what do you think? How do you think we can use the line of cases starting from Naz, Navtej, Nalsa? Because one criticism of these judgments has continuously been that they started as a challenge against Section 377. If you look at the judgments, the courts talk about how queer individuals deserve a right to equality, a right to equal citizenship. But at the end of the day, what you just got was a striking down of Section 377 and the right to engage in sexual intercourse. But do you think that these judgments can be tools that Indian lawyers and queer persons in India can use for framing better inheritance rights for themselves and better marriage rights for themselves, given that currently there's a petition filed in the Supreme Court for bringing queer persons within the SMA?
Yeah. So thanks for that question. That's excellent. We believe, or honestly, I believe, that those judgments are an important part of leading forward any law in the country. They should be tools towards that development and not the end results in and of themselves. What I mean by that is we have recently had, for the lack of a better word, good judgments, which at least attempt to protect rights. And not only do they do so, they are also, as you and hopefully the listeners would know, act as good precedent going forward. And that is sort of the answer to your question on whether individuals can use judgments to protect their rights. What I mean by that is only after a Puttaswamy, which is a right to privacy, does a Navtej come citing Puttaswamy that 377 should be read down, right? And only after these discussions does yesterday's notice of the Supreme Court to the center come on queer marriage. So not only do they build a line of judgments, they also protect laws. Unfortunately, what they do not do is guarantee these rights in perpetuity. What I mean by that is we all saw Roe v. Wade being turned down in the United States. Now, I don't expect something that drastic to happen in India anytime soon, but then again, stage itself as an overruling of a previous Supreme Court judgment, right? And it sort of leaves it to the discretion of the judges on what they want to do. And while on these big picture or big ticket items at the Supreme Court, we may not see that arbitrary inaction, and we might see protection of rights. When these have to be interpreted by a district judge in saying to what extent will you, an individual before me, inherit property, it still leaves it open to interpretation, as opposed to if the legislation was more precise and better drafted. Of course, even then, there's challenges of interpretation, but that's perhaps more in perpetuity than leaving it to unelected individuals to see what should happen.
Right. I just you mentioned about judicial bias, and I think most of the work that has been undertaken by different authors on gendered nature of property has focused on that and the analysis of judgments on the basis of, for example, interpreting a certain word differently for men and women, especially in cases of, let's say, restraint of property. So I just wanted to understand, you have mentioned in your piece that one of the reforms that we could bring about is making the legislation non-binary. However, I think when the judicial bias does exist, then do you see this being a possible directive that could actually lead to a fruitful solution? Or, I mean, we already have laws that tend to or are supposedly protective of women in the property rights domain, but that does not really end up happening. So, yeah.
No, that's correct. So I don't know if honestly this made it to the final version of the paper because it went through multiple iterations. But one of the things in these proposed amendments, there needs to be a safeguard against the proposed amendments themselves, right? So we're cautious of problems of our own recommendations. What I mean by that is just if you arbitrarily make every law suddenly gender neutral, that's not good, right? Because as you said, if there's a right specifically dedicated to protecting women's rights, I don't want that to be gender neutral suddenly and take away those rights, right? It has to be a conscious exercise going through section by section and seeing what can be made gender neutral. But to some extent, given the work on inheritance rights and property rights in this country, academics have already moved that discussion forward. We already know that Section 8 and 15 of the Hindu Succession Act are not correlated well enough, right? And they offer these differential rights to women and men and women. And so we know some of the sections that can be made gender neutral. We don't know all of them, and we should not make this a carte blanche exercise and make all legislation suddenly gender neutral.
Yeah, thank you for that. One more question that I had, I think we discussed this briefly, like Sarthak and I had discussed this briefly in one of our courses. It's about the nature of relationships that transgender persons actually end up having. So it is not generally in nature title norms would be, because it could be just a family without any proper adoption papers or anything with regards to that, no marriage specifically. So in these cases, how do you think your paper would be helpful, or like what kind of protection do we need for these relationships?
No, so I mean, first, thanks for the question, not because it's important, but also it sort of leads to some of parts of the paper which I missed out on. And so we identified primarily we looked at primarily three things or dimensions towards inheritance rights of transgender persons. One was gendered legislation, which we've talked about to some extent. But the other was difficulties in documentation. And third, of course, was judgments, which we've again addressed to some extent. So what we mean by difficulties in documentation is not only restricted to getting an Aadhaar card identifying yourself as a transgender individual, which of course has been difficult but is improving slowly over time. It also goes to being able to marry it, because only if you have the right to marriage will you have a marriage certificate proving your marriage. It also goes to adoption, because only if you can adopt as all other individuals in this country can will you have that adoption certificate. And so part of that is, and some transgender individuals follow a guru chela relationship, which some of the listeners may be aware of. And often it is possible that they do not have adoption documentation, which can be problematic, because while it's not a one-to-one analogy between a guru chela relation and an adopted child, it is not far away, right? And if you don't accord that relationship any rights under your legal framework, whether that's by rules on adoption, whether it's by dedicated legislation or judgment, if no rights are accorded to that legislation, that to me seems absurd. And I'll be as frank as I can on that matter, right? Because effectively, these are two individuals so intricately connected that the person passing away does not want their property to go to someone else. It's just that they haven't been able to make a will, right? And that's why these rights should be protected. One of the ways this can be done is to ensure that all identification documents first include an ability to identify yourself as transgender. This will not solve the problem, it will move the needle a little bit. And second, again, is to prohibit discrimination in inheritance and succession on grounds of you being a transgender individual. Again, this will not solve this problem, it will only carry forward the debate a little bit. And then is to go into some judgments which we were fortunate enough to find. And we found that in Guru Chela relations, courts have considered the fact that this was in fact the will of the person passing away, even though there was no written will, and bestowed the property on the guru or chela, as the case may have been, right? So we need to sort of look at those judgments and see how those can be adopted in practice. I unfortunately don't want to speak on behalf of how that can be done, because one, drafting legislation is a dedicated skill in itself, and to say what would be the particular change you will make is beyond my remit. But also, I don't have enough sort of lived reality to know how those individuals will want this legislation to be shaped. And of course, they should be the one leading this movement. But yes, that relationship exists. It has been judicially protected to some extent. There are ways to protect it in legislation, and we need to do that as soon as possible, I suppose.
Yeah, thanks for that answer, Karan. Taking off from your answer where you talked about Guru Chela relationships, transgender persons often engage in sex work to earn livelihood, and queer lifestyles are often not seen as normal. Queer relationships are often about friendship, and it's not just you engaging with your partner and living together. So queer conceptions of marriage and family are extremely different from what a heteronormative family would look like. So when we look at the petition filed in the Supreme Court for inclusion within the SMA, what do you think that these people are doing the right thing by going under the SMA? Because one of the concerns that has been brought up is that the SMA has a requirement of a notice, which basically defeats everything that you're looking for, which is safety and protection from the law. Because if a notice of a queer marriage is put up, there's no way you're going to be married because people will come for you. So do you think that we need a special legislation for queer marriages, or can we have a single legislation for all types of marriages within the country?
Okay, so this is sort of difficult to answer. What I can do is offer dimensions of this question and sort of leave it open to the listeners on what their thoughts on those dimensions are. So one is having one legislation in the country. That sort of goes towards your debate on a UCC, right? And to some extent, for example, I remember this is a while ago, and I hope I'm not misquoting. Abhinav Chandrachud had a piece on how we have dedicated non-religious legislation in this country on an array of personal laws, such as an SMA and an ISA, and they offer what a UCC could have offered, just in separate dedication field-wise legislation, right? So, I mean, to make an SMA a carte blanche law is to make a UCC effectively, right? And so while I don't have a position on whether that should happen or not, it should be looked at as an angle of whether you want a UCC or not. It's not just a matter of extending SMA across. On including or not including transgender individuals within the SMA and problems thereof. This has two dimensions. One is, do you need a dedicated legislation? And second is, what is the problem with the SMA itself, right? The problem of notice is the problem with an SMA. It's not a problem of transgender individuals being covered in an SMA, right? That problem serves in intercaste relationships, interreligious relationships, and there is some discussion currently that that provision itself needs to go, right? And so that doesn't have a direct relationship with transgender individuals. It will affect them without a doubt. It is not their battle to fight. Of course, I mean, I'm not to say it's not their battle to fight, but it's not a dedicated problem thereof, right? And so their inclusion in the SMA should not be dictated by problems of the SMA itself. That has to be solved separately, right? The question is, in an ideal SMA, would you have transgender individuals, right? And so again, I don't have an answer to that question, but it's better to look at it from that perspective rather than seeing that SMA has ABC problems, and so transgender individuals should not be included.
Yep, thank you. And one other question is that the thing that we grappled with while starting the column and we still face is that while we're discussing all of this, this is good discussion, this is good debate. But do you think that academia as a goal in itself, queer inclusion within academia is a goal we should be pursuing? Because at the end of the day, we're just writing papers, doing podcasts, putting out arguments. But do you think that it is for queer people to take up activism and take the burden of bringing in legislation, arguing, protesting, doing all of that? Or do you think that queer inclusion within academia is something that we should be pursuing continuously as a goal in itself? Because at the end of the day, we're not doing anything by these discussions, we're just discussing.
I mean, I don't see it as an either or, right? Yes, we need more queer representation in academics without a doubt. Ideally, I shouldn't have been the person writing this paper. And I still battle with that question on when I think of carrying forward some of that research, right? But that does not mean that queer people do not want to, not only do they not need to, do not want to take this fight forward in practice, right? So not only are the people who are doing academics need to be more involved in actual argumentation and taking actual legislation and judiciary forward. The people who are doing that part of this fight need to be represented in academics itself. What that representation looks like is a little difficult to answer, because not only do we need queer authors, we need their voices heard in peer review. We need their voices heard in case studies, right? Some of that happens, some of that doesn't happen. So we need representation across the board, but we also need both sort of, not to say that these are mutually exclusive bodies, but we both need both academics and queer persons leading civil movements as well. And so it's not really an either or. To what extent does academics achieve anything? Well, I mean, that's sort of going to my profession in general, so I'll sort of stay away from that. But I agree, like it can often be silos, but it can often not, right? And so Navtesh cites a few academics papers, and so do a few recent ones from the Madras High Court. There is that. And the second is, it's unreasonable to expect anything will change in a day, right? It's the matter of leading perspective and sort of building this ground on which a civil movement can happen, right? Because without academics, unfortunately, if you can't cite what is happening and just one individual going to an MP saying that this is my reality may not be as productive as you saying, oh, look at thousands of people are suffering through this, and there's these studies to prove it. So it's sort of a relationship between the two.
Thank you, Karan, for that. Just one question I think a lot of people who are undertaking queer research face with is what are the tools that they should be looking for? This is something that I think Sathak and I have personally faced problems with. So, would you like to talk about your research method basically and how to go about that?
So I would sort of say be conscious of yourself, right? And what I mean by that is you're speaking about a minority. And unless you represent that minority, uh, you need to be conscious of the fact that you don't, right? And that is the reason we did not delve into practical experiences, because while we did hear from transgender individuals for the paper, that is anecdotal evidence, incredibly important and useful and helpful, but that's not research per se. That was a more validating exercise and to make sure we are not being idiots at any point in time, right? But we are not the ones who should be writing both doctrinal, but definitely not lived realities, right? And unless you're part of that community, you need to be sure of that. In terms of doctrinal research itself, um, it's really I didn't experience, and again, now when I say I didn't experience, that itself is anecdotal evidence, but I didn't experience any difference in doing a doctrinal research about inheritance rights of transgender persons versus inheritance rights of women. Of course, that's also a minority, but what I mean is a general legal research stays the same, right? Your principles stay the same. You're writing to your readers, so know who your readers are, right? Don't write legal jargon if you're writing for a Hindu or a Times of India versus if you're writing for an NLS review, right? Be sure to explain what the problem is. So, for example, one of the reasons we focused on inheritance rights was because property is the largest asset of individuals in this country. Often they do not have anything else, right? And we sort of in the intro stress very pertinently on this fact that if you do not give individuals the right to property, you're pretty much taking away any possibility of income or livelihood, right? And so clarify your problem at the beginning. Yeah, so as soon as you assure, if you write to your readers, you communicate your problem and you have a good review system of listening to the people you're representing, I think that's a good start for any research.
Thank you so much for that. Do you have any final comments to add about anything?
I mean, not really. I'm thankful to you guys for having me, and this sort of needs to move forward. So I'm looking forward to the dedicated volume. But yeah, I mean, if anyone wants to ever discuss this more, and while I don't want to be on a public forum to discuss aspects outside the paper, because again, that's me taking a position, then I'd be happy to talk to anyone if they want to talk about other nuances and take this research forward.
I think that would be wonderful for us as well.
Yeah. Thank
Thank
you.
you.